Hello. Okay, so good morning to everybody, and welcome to PAX's first webinar for 2021. My name is E.G. Dizon, and I will be your host for today. Um, okay, so before we begin our webinar, I would like to set a few ground rules. First, all cameras and mics are currently disabled. This is to allow ourselves to focus on our speakers' presentations, and of course to focus on them more intently. And then second, we will be using the chat box for the Q&A during the open forum. Currently, the chat box is disabled, but it will be made available once we move to the open forum. Please be reminded that when asking a question, please make sure to indicate your name and your affiliation. Okay, so our webinar for today addresses a very timely topic regarding China's new Coast Guard law and its implications for us here in the Philippines. We are honored today by an esteemed set of panelists who will share to us their own perspectives about this matter. And so to officially start our webinar, I would like to invite Dr. Romel Banlawi, the president of the Philippine Association for Chinese Studies, to give his opening remark. Dr. Romel?
Yeah, thank you very much, EG. And thank you very much to all who are here, especially my dear friends from China, Dr. Yan Yan, and our very own Dr. THERESA CARIÑO. And of course, even on a short notice, Dr. Melissa Loha for agreeing to be with us this morning. We originally invited USEC Admiral Joel Garcia to be with us today. Because of considerable reasons and valid considerations, he needs to convince Dr. Melissa Loha to talk instead. So I'm sure that with all our experts around, we will be able to discuss this topic very productively. So with that note, I would like to just say good morning to all and have a fruitful conversations on the topic on China's Coast Guard law. Sorry about the background because this is a community, but I know you're already used to this kind of situation. So PAX has the habit of starting our program on time. So we will allow others to get in as we go along with our program. So thank you very much for your presence and good luck to all our speakers and have a productive and wonderful discussions this morning. Good morning and welcome to all.
Thank you, Dr. Banlawi. With that, we would like to move to our first speaker. Dr. Melissa Loha holds a PhD in Public International Law from Hong Kong University. Her research work has been published in international double-blind peer-reviewed academic journals. Her work on the Senkaku Diaoyu Islands was published in the European Journal of International Law, while her numerous works on the South China Sea were published in Leiden Journal of International Law, Ocean Development and International Law, and the Journal of the History of International Law. Her research article in the Journal of Energy and Natural Resources Law won the Willoughby Prize for Best Article. She's also an awardee of the 2018 Li Ka-shing Prize for Best PhD Thesis in Hong Kong University. Currently, she is a part-time associate professorial lecturer in the Department of Commercial Law in De La Salle University and is a consultant for the co-vice chair of the Philippine-China Intergovernmental Joint Steering Committee on Cooperation on Oil and Gas Development, the National Coast Watch Council, and a legal consultant to the Office of Associate Justice Alexander Gesmundo of the Philippine Supreme Court. Now, while she is currently working with these different institutions, Dr. Melissa Loha would like to inform everyone that her presentation today does not represent any of the institutions that she is currently working with, and that her presentation today is her own personal research. And so, friends, it is my honor to introduce Dr. Melissa Loha. Dr. Loha, you may take the floor.
Thank you very much for the kind introduction. Good morning, everyone. I've been heard already, or there's no problem, right? Okay. So my task this morning is to address a very important question, and that is whether the Philippines should worry about the new Chinese Coast Guard law. So most commentators on the new Chinese Coast Guard law address the issue from the perspective of balance of powers or international relations. I choose to address the issue from the perspective of international law and comparative law, principally because, in my view, more adherence to normativity or uniformity, or at least compatibility in terms of normative approach, would ensure better security and stability in the South China Sea. Moreover, I shall address the issue within the very narrow context of use of force by a National Coast Guard as a non-military or quasi-military unit which is engaged during peacetime in maritime law enforcement, regulation, and security against a foreign registered vessel. Therefore, I shall not be addressing the question within the context of maritime warfare or military activities within the sea, nor shall I be addressing issues concerning private maritime security forces or militias. Okay, next slide, please. Right, so this will be the context in which I will be addressing the question. Next slide, please. All right. Third slide, please. I will be, please move back to the third slide. Second slide, sorry. All right. To further explain the context, by use of force, I shall mean lethal and non-lethal force. By maritime enforcement, I shall mean the application of laws that prohibit certain activities in maritime zones where a coastal state has territorial sovereignty. And that would include, of course, hot pursuit occurring in the first place within the contiguous zone or within the territorial sea. By maritime regulation, I shall refer to the application of laws that do not prohibit certain activities but regulate their exercise, such as within the EEZ, when it comes to petroleum licensing or fisheries, and marine scientific research. And by maritime security, I shall mean the right or authority of the coastal state to prevent or to quell at least an act that could have an implication on the international community or on the national security of that state. And by that I mean acts such as piracy, terrorism, including poaching and trade in endangered species. All right. So let me begin by introducing the structure of my discussion. Please move to the third slide. The first part, I shall discuss the international norms that govern the exercise or use of force in maritime areas. And my sources shall be international custom as defined by international tribunals, including the International Tribunal on the Law of the Sea, as well as international conventions that codified these customs, including, for instance, Fish Stocks Agreement Convention. Second, I shall then examine the existence of transnational or regional standards by looking into the Coast Guard laws of the US, Vietnam, Japan, and the Philippines. And finally, having established the basis by which I shall address the question, I shall look into the Chinese Coast Guard law, and in the concluding part, I shall address the question in detail using as basis adherence of the Chinese Coast Guard law with international norms. So let me begin. Fourth slide, please. Okay. Now, let me begin by identifying three very fundamental norms when it comes to use of force in the maritime areas. The first norm is that of sovereign immunity. It simply states that no coastal state may exercise the authority to seize or search a vessel that is owned and operated by a foreign state for a government and non-commercial service. So this would include military vessels, and of course, they should also include Coast Guard cutters, right? Now, this particular norm is based not just on UNCLOS, but also on custom. And this is illustrated in the case called Ara Libertad case, involving an Argentinian military vessel that was docked in the internal waters of Ghana, which Ghana impounded to pay for the debts of Argentina. And the ITLOS issued a provisional order for the immediate release of Ara Libertad on the ground that it enjoys sovereign immunity as a military vessel of Argentina. So that explains the first principle of sovereign immunity. Next slide, please. The second principle is that use of force is permissible in maritime law enforcement. That is very fundamental. Let us not react to a Coast Guard law that authorizes use of force merely because of that particular provision. International law allows use of force in maritime enforcement and even in maritime regulation. But use of force is subject to very specific conditions. First is that there must be a written authority vested on the Coast Guard to make use of any form or means of force to carry out their functions of law enforcement, in particular stopping, boarding, searching, etc. Okay? So there must be a written authority. Second, the use of force must be the last recourse of the Coast Guard. It should not be the principal means of enforcement, but rather the final and unavoidable means of enforcement. Second, the use of force must be proportionate not just to the crime or the offense involved, but also to the objective, the legitimate objectives of law enforcement, right? So this particular norm is discussed in two cases. SS I'm Alone, which is a US versus Canada versus US case, and Red Crusader, which is a UK versus Denmark case, which I will mention later on. Next slide, please. Right. Now, the third fundamental norm is that use of lethal force, meaning force that could result in death or serious injury, is also allowed in law enforcement under very clear conditions. And the most basic condition is that it must be resorted to only in self-defense or in defense of others whom that person or enforcer has the obligation to protect. And that situation of self-defense must arise from a reasonable, objective belief that there is a threat to the life and limb of the law enforcer or the person being protected by that law enforcer. Absent that particular condition of reasonable, objective belief, the force that can be allowed or permitted shall only be limited to non-lethal force or an act of violence not amounting to lethal force. All right. Next slide, please. These particular norms are considered customary norms as declared by international tribunals in a number of cases, but the more basic ones are SS I'm Alone, Red Crusader, and MV Saiga. At the same time, these norms have been codified in various international instruments. These various international instruments I do not need to discuss. You can easily refer to them. But with the three cases, I shall give a very brief explanation. I'm Alone was a vessel engaged in smuggling. It was spotted inside the territorial sea of the US. The US Coast Guard issued warnings, fired warning shots, and engaged in hot pursuit. In the high seas, the US Coast Guard fired at the hull of the vessel, causing the vessel to sink, and two vessel crewmen to drown. Right? Now, the arbitral tribunal made the declaration that one, use of force is permissible in law enforcement. Two, however, in this case, use of force was excessive, use of lethal force was excessive, because the intention of the US Coast Guard was to sink the vessel rather than to enforce a customs law. Some commentators would say that that particular ruling signifies that use of force to carry out a mere regulation, such as custom, is not permissible at all. Right. The Red Crusader is very relevant to the South China Sea for it to involve fishing in contested waters. Not yet. Please go, yeah. Now, Red Crusader was a vessel that was engaged in fishing inside a contested area between UK and Denmark. Now, Danish authorities boarded the vessel, but the vessel managed to escape with two Danish law enforcers inside. Denmark gave chase and released machine gun fire at the vessel, causing the vessel to be damaged, and for a couple of the crew members to suffer serious injuries. Now, the tribunal declared that, again, in this case, there was excessive use of force because there was no prior warning shot, and two, there was no necessity for the use of lethal force, as there was no objective belief on the part of the Danish law enforcers that there was a threat to their life. Now, MV Saiga is the most relevant to the South China Sea because here, the domestic law of Ghana allowed law enforcers to apply lethal force even in the enforcement of customs law. Now, this took place in the EEZ of Ghana and not in the contiguous zone or territorial sea of Ghana. Ghana used lethal force to board the vessel Saiga and also used lethal force to arrest the vessel. Now, this resulted in injuries on some crew members. The use of force was declared illegal, primarily because, number one, Ghana had no authority, remember the norm on authority, had no authority to enforce customs laws in the EEZ, considering that customs laws may be enforced by a coastal state only in its territorial or internal waters or in its contiguous zone, unless there is hot pursuit. Right? Second, there was excessive force because there was no objective fact that would lead the law enforcers to believe that their life was in danger or that the lives of others was in danger. So that is those are the sources of the norms that I have mentioned. Next slide, please. Next slide, please. All right. Go for table, first part of the table, please. So bearing in mind the Ghana, the MV Saida case, the question now before us is whether there is a standard in the laws of various states on the use of force by national coast guards. So in this part of the presentation, I look at the practice of the United States, Japan, Vietnam, and the Philippines. And I detailed the rules and broke it down into 15 very specific rules applying to use of force by national coast guards. The first rule, of course, is on the existence of a legal authority on the part of the Coast Guard to apply force. And all 4 jurisdictions adopted specific laws on authorizing their coast guards. The second, of course, is the use of force on foreign states. Now, the US specifically provides that the use of force may only be applied when the vessel involved is foreign registered or it is stateless. Japan expressly states that it shall not apply to foreign state vessels. Vietnam is silent on the matter, as well as the Philippines also states that it should not be applied on foreign state vessels. The third rule is whether there is an identification of the zones where lethal force can be applied. With respect to the US, they have a concept of jurisdiction beyond the waters of the US, specifically in foreign internal waters, archipelagic waters, and territorial sea, where the life of an American citizen or the preservation of an American vessel is involved, and the coastal state is unable to protect that citizen or vessel, right? With respect to Japan, the law provides for application of use of force in the internal and territorial waters and in the high seas with respect to piracy. Vietnam does not specify the zones where use of lethal force can be resorted to, whereas the Philippines specifies that use of lethal force can only take place in internal waters, archipelagic waters, and territorial seas, as well as the contiguous zone. Not sure if you can see the bottom part. The fourth rule is whether the law allows use of force as a last recourse. The US law provides that there has to be an exhaustion of efforts before use of lethal force is adopted. With respect to Japan, it is only when there is no other means to stop the commission of a crime that lethal force is adopted. The Vietnamese law is silent on the matter, whereas the Philippine law also states that it has to be the last recourse. Next slide, please. First, the fifth rule is that there has to be a basis of necessity and reason to adopt use of force. Here, the provisions of the US law, the Japanese law, and the Philippine law expressly provides that that use of force should be the last recourse. I would flag the Vietnamese law as problematic, principally because, are you able to see the provision? Sorry, I think there's a bar that blocks the. Maybe if you could just remove that bar. The. All right, let me just say it then. The Vietnamese law, I flag it for being problematic because it says the Coast Guard may open fire when violators use weapons to oppose or employ other means to directly threaten the lives and safety of the Coast Guard. That's a valid provision. However, it also provides that the Coast Guard may open fire when chased persons and means that commit serious violations may escape unless weapons are used. Right? So it's a direct recourse to force in a situation of flight. Okay. Now, the sixth rule is use of force for a legitimate purpose. All of the provisions require that the use of force be in line with an enforcement or regulation activity. The seventh rule is about whether the use of force is confined to certain offenses. And here, the US law expressly precludes use of force in violations of fishing, vessel safety, immigration or documentation, and pollution laws. Right? All the other countries do not make a preclusion on use of force for purposes of regulation. Now, what then are the conditions before lethal force can be resorted to? The US law expresses states that there has to be imminent threat of death or injury on the law enforcer or on another person. With respect to the Japanese laws, lethal force, of course, can also be done in case of self-defense, but it also countenances lethal force even for the purpose of merely suppressing resistance or preventing escape. The same is true with the Vietnamese law. With respect to the Philippine law, it requires self-defense and not just enforcement or prevention of escape. Number 9, whether defense of self and others is a necessary precondition. As I said, the US law expressly provides that there should be defense of self or others. With respect to Vietnam, yes, there is a situation where self-defense and to avert present danger is also a justification for lethal force. But with respect to Vietnam, yes, they also require lethal force or allow lethal force as a matter of self-defense, as well as in situations of escape, as I have mentioned. The same is true with the Philippines. Next slide, please. All right. Now, there is a fine line between defense of the law enforcer and defense of the vessel or the larger unit of the Coast Guard. The US provision provides that there can be lethal force in order to safeguard the unit itself or the vessel. With respect to the other laws, I'm sorry for the typo. With the Philippine law, yes, there is also a concept of defense of vessel. Now, with respect to the target of the use of force, remember that in the case of Red Crusader, the tribunal ruled that there was excessive force because there was disregard of the presence of innocent lives in the vessels when Denmark opened fire. Now, in this case, the target has to be specified in the law itself, and the US law provides that it should be the offender giving cause to a threat to life or limb. However, the US law provides for recourse to airborne lethal weapons. And of course, although there is a restriction that there should be no reasonable ground to believe that innocent lives are involved inside the vessel, any recourse to airborne weapons, of course, could lead to indiscriminate death or injury. With respect to the Vietnamese laws, of course, it always provides violators are the target of the recourse. The 12th rule is restriction as to purpose. All of them would require that the use of lethal force is for prevention of the crime or stopping of the threat. As to the type of weapon, only the US allows airborne weapons, all the rest allows seaborne or handguns. As to the nature of the offense, where that would give rise to use of lethal force, the US again expressly states that it should not be resorted to only for the purpose of enforcing fisheries and other mere regulations. Finally, the restriction on use of force within the maritime zone is not clear with respect to the US because of the provisions on the extension of its enforcement jurisdiction in the internal and archipelagic waters of a foreign state. But with respect to the Philippines, it expressly states that it can take place only in internal waters and the territorial sea continued zone. With respect to Japan, high seas crimes can give rise to the use of force. Next slide, please. All right, sorry. So based on this discussion of the norms of other states, the very fundamental conclusion that I can arrive at this stage is that number one, there is no uniformity or compatibility in terms of their norms. Second, at the very least, they require self-defense in order to justify recourse to lethal force. With respect to whether the norms are themselves in conformity with the international norms that I have discussed earlier, well, it is quite obvious that there are some excessive provisions, especially on lethal force for purposes merely of law enforcement rather than self-defense, and lethal force even, or use of force in general, in maritime zones outside the jurisdiction of the coastal state. So with that in mind, having established the basis by which we can now look and address the question of whether the Chinese Coast Guard law would give rise to some worry for the Philippines, let me now look at the provisions of the Chinese Coast Guard law, making use of the same 15 rules that I applied with respect to the laws of the 4 other countries. So the first rule is that, yes, there is a written instrument. Now, the issuance of the Chinese Coast Guard law is itself a form of compliance with this particular norm in international law, that the use of force must be based on a written authority, which, of course, that written authority would contain certain limitations on that use of force. Second, the authority to use force on foreign state vessels. And here, I would flag Article 21, which provides that if there is a foreign military vessel or foreign government vessel inside the territorial sea or internal waters of China or in waters under its jurisdiction, then after giving warning or requesting that that vessel leave, Article 21 gives the authority to use force in order to make that vessel leave. All right. Now, of course, the provision requires that there must be some serious harm or threat arising from the foreign vessel. The third rule is on the maritime zone where use of force can be resorted to. And here, I would flag Article 12J, which provides that China or the Coast Guard can make use of force even in areas outside the jurisdiction of China, provided that it is in connection with the enforcement of environmental norms, right? Number 4, use of force as a last recourse. Well, Article 17, 18, 20, and 47 provides that use of force should be the final recourse. 5, use of force based on reason and necessity. Article 50 gives a discretion to the Coast Guard to calibrate the force according to nature, degree, and urgency of the offense. Next slide, please. All right. So here, again, use of force must be for the following purposes: to stop an offending vessel, or to prevent an escape, or to forcibly drive away or tow a ship that's been offending, and other situations of criminal acts that need to be stopped on the spot. 8 conditions under which use of lethal force may be reasonable. And here we have a situation where mere enforcement or mere the need to stop a flight already gives rise to a justification to use force, which is not in accordance with the norms that we have discussed. Now, number 9, defense of self and others is also justified. And here, it is also an adopted norm in the Chinese Coast Guard law. And here, it is critical, and I flagged Article 48C, which provides that in order to defend a vessel or aircraft which is being attacked or in danger of being damaged, then the Coast Guard may call upon the use of airborne weapons. And as I mentioned, this can be problematic in terms of containing the damage or the effect, the casualty in terms of under international law. With respect to the other norms, the provisions of the law are vague or are absent in order to address each of them. So let me go now to the concluding portion. So in conclusion, to address in detail the question whether the Philippines should worry about the Chinese Coast Guard law, I would mark five provisions that could give rise to some concern. And that is: 1, authorization to use lethal or non-lethal force even if there's no threat to the life or limb of the Coast Guard or the personnel, even if it is only in the course or as a means to enforcing a regulation or a law or to preventing flight with respect to the vessel, the offending vessel concerned. Now, of course, this is similar to the Vietnamese law, which allows a Coast Guard to open fire only for the purpose of enforcing a law or for preventing flight. Now, second is the extraterritorial or extramarital zone, maritime zone jurisdiction, similar to the US law. The difference between the two is that under US law, the extraterritorial reach is justified to protect a citizen or an asset. With respect to the Chinese law, it is to enforce an environmental law or an environmental norm. Third, the use of airborne weapons by both the US and China, as this could lead to indiscriminate death or injury. Fourth, the use of lethal force or use of some form of force on claimant states that are engaged in building artificial structures without providing for certain qualifications, such as when that particular state is engaged in building artificial structures in areas or rocks where it has already been occupied, which it has already been occupying. Okay. Five, the fifth cause for concern is the use of little force to enforce mere fisheries and other economic regulations, like the US law, which expressly precludes use of force in those situations. And finally, this is something that, for me, is actually a positive development in adopting a written Coast Guard law. China is adhering to a very fundamental norm that the authority of its law enforcers be set in a written instrument and strictly confined within the four walls of those instruments before they can engage in law enforcement that in the past could be arbitrary precisely because of the absence of these legal instruments. Thank you very much. Thank you for your time.
Okay. So thank you, Dr. Loha, for that insightful presentation. So now, please allow me to introduce our two reactors for today's webinar. So our first reactor is Dr. Yan Yan. She is the Director of the Research Center of Oceans Law and Policy in the National Institute for South China Sea Studies. She received her PhD in the University of Hong Kong, or HKU, on Public International Law, and her MS degree from the London School of Economics and Political Science. Her research interests cover areas such as the law of the sea, maritime security in the Asia Pacific, China's maritime law and policy, and the South China Sea. Her recent publications include the following: prospects and legal obstacles of joint development between China and the Philippines in the South China Sea, the Code of Conduct, negotiation history, and the way forward, maritime confidence building measures assessing China-US MOU on notification of major military activities and rules of behavior, and many others. So with that, may I call Dr. Yan Yan for her reaction.
Thank you, Chair. And first of all, I would like to thank the organizer for inviting me to attend this webinar. I think this is a very timely and very interesting topic. And I also, first of all, I also wanted to thank Melissa for sharing with us your newly research products. I think Melissa's a review of the international norms and the cases of use of force in law enforcement operations are really nice, and I agree with that. And also, it's very inspiring to see Melissa's comparative analysis of the Coast Guard law of different countries, U.S., Japan, China, Vietnam, etc., and the Philippines. I think that's extremely good. And I wanted to say that I do agree with Melissa that the international law does not forbid the use of force in law enforcement operations, because when I saw some reports and also some remarks of government officials saying that the Chinese Coast Guard law of use of force is against the international principle of non-use of force, forbidden of use of force in international law. I think that understanding is extremely incorrect. So I'm happy that we all agree with that, so that we can go into much more detailed analysis of this issue. I wanted to say that of Melissa's analysis of the Chinese Coast Guard law, I wanted to mention that except China's Coast Guard law, the new one, the newly enacted one from February the 1st, actually we have previous law that also governing the issue of law enforcement operations at sea. And the most for example, like the law of police, of policemen, and also the law of armed police. And what is more direct connected with this issue is the the regulation of the People's Republic of China on use of police implements and arms by the People's Police. Well, in that regulation, they set out several more detailed conditions and circumstances, whereas Chinese police can use force in under those circumstances, and that regulation was enacted since the year 1996. So that one, I recommend everybody wanted to do more detailed research on this issue, or you could look at those. I think that in the South China Sea, the fundamental issue is that we have disputed waters, and so that the maritime law enforcement operations may have a problem. Or there are basically two scenarios. Like the first one is that the law enforcement vessels clash into each other, or faces each other and have a collision. And the second situation is law enforcement vessels versus fishing vessels. Well, those situations, in both situations, I think the rules governing use of force may vary, because when government vessel versus government vessel will both have the sovereign immunity, so that it will be more relevant to the UN Charter Article 2, Paragraph 4, the forbidden of use of force, that would be more relevant to that. However, the government vessel versus fishing vessel is another story. It's more like a policing activity to enforce the domestic law in regards of the jurisdiction of resources, development, etc., over foreign fishing vessels. And those are the two scenarios happening in the South China Sea. Well, look back, the Chinese Coast Guard. I wanted to have a short review of this formation and how it works of the China Coast Guard. Well, actually, the problem, no, not the problem. The China Coast Guard Bureau, it was reorganized back in 2013 based on the former State Oceanic Administration of China, as well as China Marine Surveillance, the Border Security Force of the Ministry of Public Security, and the Chinese Fishery Law Enforcement of the Ministry of Agriculture, and the Maritime Anti-Smuggling Police of the General Administration of Customs. So it is an organ combined by this formerly five maritime law enforcement agencies altogether. And it is a China's maritime law enforcement agencies to exercise the maritime rights, responsibilities, and obligations under international law. Yes, including the UNCLOS. Well, since the year 2018, the MPC, the Standing Committee, adopted the decision on the exercise of maritime rights and law enforcement powers by the China Coast Guard Bureau, which placed the China Coast Guard Bureau under the command of People's Armed Police Force. So the issue of how the Chinese Coast Guard could use a force as an armed police force becomes a hot topic since then. And before, China is criticized of lacking of sound legal basis of law enforcement operations at sea. Well, although we do have other domestic laws regarding this issue, but we were criticized a lot for the past few years. So I think the new Coast Guard law this brand new thing is actually a very big progress to the law enforcement agencies working at sea. The most recent one, I think the primary a positive implication of the new Coast Guard law is that it provides the legal basis for the Coast Guard to perform the task, and further clarifies the legal identity of the Chinese Coast Guard as a civilian law enforcement agency during peacetime. And it also clarified the CCG's rights, functions, and obligations, including the administration of maritime territory under Chinese jurisdiction, and execution of other tasks such as the international cooperation. So I think these are the very positive aspects of this new law of the Chinese Coast Guard. My second point is that I wanted to say, although people all focusing on the use of force issue of the Chinese Coast Guard law, but it is actually a very a small part of the whole law. Well, it has 85 articles, and what only about 10 articles are regarding provisions are regarding the use of force. We have many important other chapters in this law. Like for example, chapter 9, chapter 10. I wanted to mention that although it stipulates the situation where China's Coast Guard, when doing maritime operations at sea, can use force. However, it does have chapter 9, which is about the supervision and legal responsibility. Well, actually, it sets up a whole set of rules covering the discourse, recording, and accountability for faults. And also, all those provisions are trying to guarantee that those law enforcement activities are necessary and proportionate. So I think that chapter 9 is worth mentioning, and it's also worth introducing to everybody who's interested in the new Coast Guard law. And also I think that chapter 10 is important too, because it regulates the maritime cooperation between China Coast Guard and foreign law enforcement agencies. It sets out the mechanisms there, because if we look at China and the Philippines, for example, in the year 2016, China and the Philippines signed a memorandum of understanding between the two countries' Coast Guard on the establishment of a joint Coast Guard Committee on Maritime Cooperation, which has so far held 3 meetings. And also last year, in January 2020, the Chinese Coast Guard conducted a joint search and rescue and firefighting exercises with our Filipino counterpart. So before the Chinese Coast Guard law enacted, we don't have much legal mechanism set out for maritime cooperation between law enforcement agencies, between China and the world. However, now we have it. We have the chapter 10. Well, the chapter 10 is designed to improve bilateral or multilateral maritime enforcement activities. So I think those are the chapters that I wanted to mention. And also my final point is that I noticed, I'm sorry, I didn't have see all the details of Melissa's PowerPoint very clearly, but I do notice that some of the provisions that you analysis in your PowerPoint is a little bit different from the Coast Guard law that I have in my hand, because maybe some of the provisions that you have are from the draft, right? Like for example, regarding Article 12J. Well, I don't have the exact same wording that you have in your form, like Article 12J. The Coast Guard is responsible in undertaking fisheries supervision and other law enforcement tasks in areas outside China's jurisdiction. Well, this wording is not the same as the one that is finally adopted and enacted, the final one. So it's not in my Coast Guard law version. So I didn't check all the details, but I do think that the Chinese Coast Guard law, I think it does not exceed what international law requires, and also it does not it is in conformity with other state practice. So I think there are probably some detailed things, but I think the most important thing is that in absence of specific actions, many of the doubts and skeptical opinions regarding the Chinese Coast Guard law that I saw on media and also saw by some government officials are groundless. I think most of them are hypothetical questions. And I think that the most important thing is that for the time being, I do understand that countries will be paying very close attention to what the Chinese Coast Guard do in our surrounding waters. and they will keep a close attention to the scope and application of this law. Well, for those attentions, I can totally understand. And all I wanted to see is that we can let's just wait and see how it is implemented. Thank you.
Okay. Thank you, Dr. Yatian. Wait. So, Dr. Loha, can we temporarily stop the the screen sharing there? Thank you. There. So, thank you, Dr. Yan Yan, again for that insightful perspective about your own reaction to Dr. Loha's presentation. So now we move to our second reactor. Dr. THERESA CARIñO is a board member of the Philippine Association for Chinese Studies, which she helped establish in 1987. A Singaporean, she taught political science at De La Salle University, where she established the China Studies program. As founding director of the Philippines-China Development Resource Center, she promoted educational exchanges between the Philippines and China on areas such as poverty, health, renewable energy, and sustainable development. In 2001, she became the director of Amity Foundation's Hong Kong office. And since 2010, she has contributed to research and capacity building for Amity at its headquarters in Nanjing. A senior research consultant and Amity advisor, she continues to research on themes related to religion and sustainable development in China, China's relations with Southeast Asia, and the Chinese in the Philippines. Books that she has authored or edited include the following: China and the Overseas Chinese in Southeast Asia, Chinese Big Business in the Philippines, Leadership and Political Change, Christianity and Social Development in China, and Toward a Shared Sustainable Future, the Role of Religion, Values, and Ethics. And so with that, I would like to invite Dr. THERESA CARIñO to give her reaction. Dr. CARIñO.
Thank you, E.G., for that very generous introduction. It's a privilege and honor to be here in this panel today with two very distinguished scholars on international law. I am responding today, I want to say at the outset, more as someone who lives in Southeast Asia and has worked in China for a long time. I'm neither an expert on the South China Sea, nor on coast guards, nor on maritime law. But like most inhabitants in Southeast Asia and East Asia, I do have a stake in the peace and security of the region. Not only is the South China Sea a growing source of conflict as a result of overlapping claims between China and its neighbors, it's also a hotspot in the struggle for dominance between the US and China. Here, I would like to thank and congratulate Dr. Melissa Loha for her detailed and enlightening presentation on China's new Coast Guard law that only came into force on February 1st. In contrast to the very agitated reactions of some diplomats and politicians in the region, Dr. Loha has taken a very calm, measured look at China's new Coast Guard law, putting it in a comparative perspective with other Coast Guard laws in the region and with the US. Her conclusion is that there are about 5 or 6 sections of the law that are cause for worry. And all of them have to do with the use of lethal or even non-lethal force, as well as extraterritorial applications, the use of force against claimant states engaged in building artificial structures, and so on. I won't repeat what she said. And I'm really grateful that Dr. Yan Yan has given a very helpful background on the formation of the China Coast Guard law. And you know, we all need to understand it has taken years for the law to be formulated as we see it today. So it's taken a lot of effort and consideration. And I think Dr. Yan Yan has given us very good insights on that process. To date, the new law remains untested. But from the Philippine perspective, especially in areas of overlapping claims in the South China Sea, there are fears it could be used as legal cover to prevent Filipino fishermen, for instance, from fishing in the Panatag or Scarborough Shoal or other areas. Or it could be used to block Philippine-sanctioned foreign firms from exploring oil and gas in the West Philippine Sea. Even before the adoption of the law, Filipino fishermen had already reported incidents of harassment and intimidation. In this context, the law's passage has served to heighten, not dissipate anxieties. For instance, Hamalakaya, a fishermen's organization in the Philippines, has called on the UN to declare the Chinese Coast Guard law as null and void. So this is a very strong reaction. But to an extent, China's new law, as indicated in the previous presentations, follows a trend among Asian countries. Dr. Loha has indicated Japan's Coast Guard law authorizes the use of weapons against foreign vessels within Japanese waters in situations deemed reasonable and necessary. South Korea authorized its Coast Guard officers in 2016 to use handguns and onboard cannons against Chinese fishing vessels operating illegally in Korean waters. Likewise, Vietnam's new Coast Guard law, passed in 2018, grants its maritime law enforcement personnel greater latitude to open fire at sea. All of these signify, for me, the growth and militarization of Coast Guards in Asia. It reflects both the growing economic strength of the region, but also the translation of its wealth into military buildup. There is also evidence that littoral states in the South China Sea find it increasingly necessary to counter a growing spectrum of non-traditional maritime-related threats, such as arms and drug smuggling, human trafficking, piracy, illegal fishing, and militancy, not to mention marine environmental degradation and natural disasters. Nonetheless, increasing the use of force also raises the risk of unintended encounters and incidents in the South China Sea. The onus falls on China to calm its neighbors. And this has to do with the fact that it has the most extensive claims in the South China Sea, and therefore runs a much higher risk in creating more incidents of overlapping claim on atolls and reefs, as well as EEZs. The fear of China and its future intentions does not arise from the fact that it has a new Coast Guard law. I think it comes from this asymmetry in maritime capabilities between China and other claimants. So there is much that China can and must do to assuage regional fears over its new Coast Guard law. It can show greater political will to engage other regional maritime law enforcement agencies so as to lower tensions and the risk of incidents at sea. It's encouraging, for instance, that Clause 64 of China's Coast Guard law specifies managing and controlling maritime crisis as a primary international cooperation task for the CCG. Coast Guard cooperation can be seen as a confidence-building measure, and it has been. But I think in the region, any kind of real cooperation and effective cooperation has to include the two major powers, the US and China, lest there are suspicions that that kind of cooperation is directed at one or the other. I think it's helpful to know, and this I got from Professor Banlawe, is that in 2016, the China-ASEAN leaders meeting made some progress when they agreed on a diplomatic hotline to respond to maritime emergencies and a joint agreement to implement the CUES, which stands for the Code for Unplanned Encounters at Sea. CUES is a non-binding agreement that provides safety measures as well as basic communication and maneuvering instructions for naval ships and aircraft for unplanned encounters at sea, but at the present moment, it only applies to navies. So in a visit to China in 2016, Singapore's defense minister suggested to the Chinese that CUES should be expanded to cover both naval and coast guards. Let me end my remarks with an appeal. I think ASEAN members and China can and must work harder to finally agree on a code of conduct in the South China Sea. This has been long overdue. At the same time, a multi-layered approach to maritime dispute arrangement or management can help cooperation and the peaceful management of conflicts in the South China Sea. And for me, important areas for cooperation, which are urgently needed, ought to include marine environmental security, fisheries cooperation, and possibly the application of the UNCLOS as a framework for ocean governance. Progress in these may take time, but it may help contending parties take the long view and work towards viable solutions, avoiding the use of force. This is my hope and my appeal as a stakeholder in the peace and stability of the South China Sea. Thank you for listening.
Thank you, Dr. CARIñO. So we are now moving to the open forum of our webinar. If you notice, the chat feature is now accessible. Again, we would like to remind our participants to please include your name and your affiliation when you ask your questions on the chat box. And of course, please also take note if you would like your question to be addressed by a specific speaker, please indicate their name as well. Okay. So I guess since we have a few questions here, we could already start. So we have a question here from Hermie Colina asking, isn't the Chinese Coast Guard law a tacit admission of China's claim in the West Philippine Sea, and discussing likewise admit its actual effectivity? I think there is a follow-up to that regarding the use of lethal force. Focus is on the use of conventional weapons, which I think was mentioned earlier. But how about the use of the ship itself as a lethal force, such as ramming another vessel, which I think has been the case in from a few years ago. So to any of our panelists who would like to take that question?
Yes, well, I can answer the questions. Well, I have basically 2 points. And first of all, regarding China's South China Sea claim or or China's maritime claim as a whole, both in the East China Sea, Yellow Sea, and South China Sea, the Coast Guard law does not have anything to do with the China's maritime claims. Well, our China's maritime claims are, I wanted to say it is consistent and it remains the same. If you wanted to know more about China's South China Sea claim, I suggest you to look at the China statement on our maritime claims in the South China Sea and maritime rights, published by the Foreign Ministry on date July the 12th, 2016. Well, I think that statement clarifies China's South China Sea claim in a and categorize what we claims in the South China Sea. For example, we claim four island groups in the South China Sea, and we think that in the South China Sea we have territorial sea, exclusive economic zone, contiguous zone, etc., etc. So our maritime claim does not change at all by the Coast Guard law. It has nothing to do with the maritime claim. So that's my answer to the first question. And then the second one about the lethal force, and also it would be the comment to Madam Theresa's comment just now regarding whether China has the most, because of the asymmetric maritime power, that China is the most powerful country, maritime power in the region, that we have the most possibility to conduct a maritime conflict with our neighbors. I personally don't agree with this point of view. And also, I think that China never used vessels or other lethal force in terms of when doing our maritime law enforcement operations in the South China Sea. I will give you an example. Like, for example, in the South China Sea, there are examples of using lethal force among coastal states. And it happened many times in the region. For example, the most recent ones, last August, it's only like half a year ago, Malaysian's maritime law enforcement law enforcement officers fired during the collision with Vietnamese fishermen. And last August, one Vietnam fisherman died last August. And the Malaysian maritime law enforcement officer says that because the Vietnam is conducting illegal fishing in these waters, and they throw these handmade bombs and weapons to these Malaysian law enforcement officers, so that they're self-defending themselves and fired, and then which resulted in the death of one Vietnamese fisherman. And then also in the year 2019, there are lethal force level maritime law enforcement clashes between Indonesia and Vietnam as well. I think that was in 2019 in February, when the Indonesian Navy, because for the Indonesian Navy is their law enforcement agency, they're conducting the law enforcement operations at sea. Well, those people, their Navy shoot a cannon. I don't remember what millimeter cannon to drive those Vietnam Coast Guard vessels away. And then they take back a dozen of Vietnam fishermen back to Indonesia, and some of them are dropped in the waters. And then the Vietnam Coast Guard vessels were there too. And there are these are also the examples of using force and even lethal force during law enforcement operations at sea in the South China Sea. However, if you what I mean is that if you look at the history in the South China Sea, well, China never used a lethal force in terms of in our maritime law enforcement operations. So that's what I learned from history. I do understand, as I already mentioned, that I do understand that people are keeping a close eye on what the Chinese Coast Guard will do in the future. But what I think is that China's Coast Guard will continue to exercise this very high level of self-restraint, and I think use of lethal force will be our last recourse to do during maritime law enforcement activity. as my answer to those questions. Thank you.
If I may. Hello. If I may, Iji.
Yes, Dr. Loha, you may speak.
Okay. To begin with, thank you very much for the very substantial comments coming from THERESA and Yan Yan. They will enrich further research into this topic. At the same time, let me address a comment from Yan Yan regarding Article 12J. This is found in the English translation. Let me just say that the laws that I made use in my research are unofficial English translation of the legislations. However, I looked at 3 different sources and compared the text for purposes of verification, as I have no linguistic knowledge and I could only rely on the sources that are available. And this is what I found in the Chinese law. And as I flashed in the screen earlier, there is a provision similar to the US law on an overreach of its jurisdiction. And in answer to the question, the series of questions coming from Hermie, let me address the first one. And this is to do with a refusal culturally from the point of view of the Filipino, as well as Filipino journalists, to bury our head in the sand as though we are ostriches and ignore the reality. The Chinese Coast Guard law is part of the operative fact bearing upon foreign relations and foreign policy. We have to confront this text and discuss it. Now, the effectivity of a law, similar to the effectivity of a Philippine law, does not depend on whether China, Vietnam accepts our law. We have the jurisdiction to prescribe laws and to adjudicate violations of these laws. And therefore, the first question has no basis in law and in fact. As to the second point, there is a specific special regime when it comes to the use of vessels to ram another vessel, and that is under international law, under the jurisdiction of the IMO on safety of navigation. It is not part of the regime on use of force. Okay. Going to the third point from Hermie on whether there is hot pursuit, yes. As I mentioned, if you were able to listen to the discussion on MV Saiga, here the hot pursuit commenced in the EEZ to enforce a customs law. And the tribunal declared that number 1, Ghana has no jurisdiction nor authority to enforce customs law in the EEZ. The hot pursuit has to commence in either the territorial sea, internal waters, or the contiguous zone. In this case, the hot pursuit took place in the EEZ, and therefore it was unlawful. So in the Coast Guard laws that I've mentioned, hot pursuit is very much part of the provisions indicated therein where there is a situation of flight. Now, with respect to the question of Dr. Banlawi, based on the text of the Chinese Coast Guard law, its application would be in the internal waters or inland seas of China, territorial sea, contiguous zone, and waters under the maritime jurisdiction of China. Therefore, CCG has everything to do with the maritime disputes in the South China Sea, principally because China is asserting jurisdiction over certain waters that are disputed with the Philippines, Vietnam, and Malaysia. Thank you very much.
Yes, Dr. Yan Yan. Thank you, Dr. Loha.
Thank you, Melissa. Thank you very much. And I just wanted to add one more thing regarding the applicable maritime areas that Melissa said. I agree with what you said, and I think there is one other maritime area that is applicable. That is the Article 12, paragraph 2. That is the area outside the maritime jurisdiction that China has. according to the bilateral or multilateral on. Well, because in my mind, there is one example like China and the United States Coast Guard have cooperated for many years, for about 15 to 2 years in the North Pacific, in the high sea, in terms of joint efforts of combating polars, whatever. So those areas are, although they're in the high seas, but according to the bilateral treaty between China and the United States, those have the in those areas falling on Asia. And another question from Admiral regarding the China-U.S. competition in South China Sea, in the Alaska dialogue. And this is a very, very nice press for following U.S. position as well, because I follow those the dialogue as well. I think that during the China-U.S. dialogue in Alaska, there's one interesting thing that that catch my eye is that the South China Sea issue is only a very tiny issue during the whole dialogue. It's not like the dialogue from last year. It's like the two countries only contributed a very limited time talking about the South China Sea, and it's only like our own policies that each side already know. They didn't touch upon many controversial or very tense issues, etc. So I'm not sure whether that is a sign of possible future cooling down of tensions of China-U.S. strategic competition in the South China Sea, but that is a very interesting thing to look at in the Alaska dialogue. And also, I think regarding the U.S. South China Sea policy, I think what is worth mentioning is last year's July the 13th, Pompeo's remarks and statement on the South China Sea, which he stated very clearly what he sees China's claims in the South China Sea, and how he is supportive to China's neighboring countries' joint developments of and exploration of oil and gas resources in the region, and also his opinion, the U.S. opinion on the negotiation of the code of conduct, etc., etc. I think that the U.S. South China Sea policy hasn't changed. And then since last year, they have new moves in the South China Sea in terms of the sanction of the 24 Chinese companies that has been involved in the South China Sea projects, etc., etc., and trying to link the South China Sea to the One Belt One Road project. I think the U.S. has been continue to pay attention to the South China Sea issue. And also this year is the this year the visiting forces agreement between U.S. and the Philippines has already under review, because last year it was postponed for two times. So this year, what I'm interested in is also, besides the China-U.S. competition in the South China Sea under the Biden administration, but also the U.S.-Philippines alliance and how they will go, especially the Philippines the presidential election is coming next year. So my interest is also regarding the U.S.-Philippines alliance. I think that will make a very interesting impact on the South China Sea situation itself. Thank you.
May I respond to the new question?
Yes, please, Dr. Loha.
Yes, this is an observation or frustration that I have had with the Philippine media, and it has to do with the lack of research backing up news articles and reliance on mother lines or established statements regarding the South China Sea. I think there is need for the media to understand international law, not as experts, but even just a working knowledge of international law. And this is something that I hope PACS would be able to undertake for purposes of making the media understand international law and therefore use it to interpret certain events and present it in a way that will not perpetuate the lack of understanding of the Filipino public regarding the South China Sea and even regarding the final award. I hope that in the future, the Philippine media will be able to contribute towards the resolution of conflicts rather than generate further misunderstanding that can only exacerbate the conflict. Thank you.
Yeah.
Yes, Dr. Yan Yan. Thank you, Dr. Loha. Dr. Yan Yan, yes?
Thank you, Melissa. Well, I'm thinking the same thing, and also to the Chinese people, I think the understanding of the South China Sea, what it is, and trying not to generalize this national sentiment is very important for us to have an objective understanding of what is happening now. And also regarding the last question regarding productive cooperation, and also about the Madam THERESA just mentioned the expansion of the queues to Coast Guard. I think that I do have a point to share here. I think that, well, first of all, the expansion of queues to maritime law enforcement agencies is honestly unnecessary and inappropriate, because if you look at the queues itself, it is designed by nature for the navies. The purpose of the queues is trying to restrain the Navy's activities when they're conducting self-defense, even when they're encountering each other. So that the coding, the channel, the wording, and those flags and everything are designed for them to communicate with each other, even not using the language. However, the law enforcement agencies, well, their operation is in nature different from what the navies do. Well, they're trying to enforce law of their domestic law in the jurisdictional waters. And also what they are facing mostly are the fishing vessels. So it's fundamentally not possible to conduct those coding and channel communication with fishing vessels because they don't even have those equipments. And it's impossible to imply all those equipments to put all those technical things on the fishing vessels in the whole South China Sea. It's just by nature impossible. However, we do need to increase understanding between law enforcement agencies in the region. I do wanted to recommend a project that has been ongoing since the year 2016. I remember that was organized by one NGO from Europe, the Humanitarian Dialogue. I think all our countries' coast guards, including Vietnam, the Philippines, China, Indonesia, all participated in this project, and they have already come through a COPS, Common Operational Procedures, that all of the coast guards have been agreeing on through this project. This is, I think, it's an attempt. It's an from the bottom up attempt and trying to create dialogue and understanding among those law enforcement officers at sea. I think this is a very meaningful project. I participated as a legal expert for several times, and it is an ongoing project. And I think that and also during those conferences, I've been communicating with Philippines Coast Guard officers and Vietnam Coast Guard officers as well. And I think this is what the regional maritime law enforcement agencies need, not the queues, but a corps of all agreed. And that's my suggestion. Thank you.
Thank you very much. Yeah. May I just say something? I'm Mr. Moderator. Yeah, I'm really grateful to the contributions of Melissa and Yan Yan today. I've learned a lot. And this is the kind of exchange and understanding we need to cultivate more. And I agree completely that Philippine media has not done enough research, does not have enough background, and often just echoes what is already in Western media. And I think that's too bad. Perhaps PACS can do something about having more exchanges or visits of media to China, or have exchanges and dialogues about certain pressing issues. We need to get together and think of how this can be done. But it certainly is a very crucial area, because media is helping to shape public opinion. And I think it's very dangerous when so much is, I mean, there's a lot of China bashing now. And I think we can expect more of that with the elections coming around the corner. So I think these kinds of measures to bring about better understanding is very crucial. So thank you very much for your suggestion.
Thank you, Dr. Carino. So I believe we are already pressed for time. So with that, maybe I would just like to ask our speakers for their closing statements. No? And for that, maybe start with Dr. Loha.
So in closing, if we can make a discussion which is dispassionate, which is based on facts and research, and involving all the parties, including someone from China, there is much hope for a peaceful settlement of our disputes in the South China Sea. Thank you very much.
Thank you. Dr. Yan Yan.
Well, I really thank the organizers for giving the chance for me to meet my old friend Melissa, and we haven't seen for each other for like at least 3 years, 4 years, and I'm so happy to see her outstanding academic achievements now, and I really wanted to see her new paper coming out, and I would definitely quote that in my in my new research regarding the Chinese new Coast Guard law, and also. I'm working for a think tank in China, and we also make suggestions to the government and also to the public of what we should do in the future. So I do think that many of Malaysia's analysis is helpful to us as well. So that because any law will be revised, right? And China is even in China that we have revised the like the maritime traffic maritime law, etc., last year, so that if there is anything inappropriate in the law, we will definitely make suggestions also to the government to see whether we can make it better in the future. And I also thank Romel, an old friend from the South China Sea Studies, and also thank Madam THERESA and also PACS. I think this kind of communications are extremely important, and I do enjoy this kind of dialogue. Thank you very much.
Yeah.
And thank all the questions.
Thank you, Dr. Yan Yan. Dr. Carino.
I think I already made my closing statement earlier, in hoping that there will be more research and follow-up after this. I think this is very important. Very often we have webinars and then we forget about it, and then we meet again after 3 years. But I think this is really very crucial about the South China Sea. And I think PACS wants to put it in the center of its activities and research interests. But I also want to advocate that we do more research as well, not only on militarization and all the difficult problems of conflict, but how to resolve a lot of the problems internal to the South China Sea at the level of human security. So I really look forward to more exchanges and networking with all of you. Thank you very much.
Thank you. Thank you, Dr. Carino. And of course, thank you to our speakers. Perhaps before we close, I think, can we take a picture of everyone who's still here? If you if you're willing to please open your cameras temporarily. There.